Thank you. Thank you very much for the introduction. Welcome to everybody, and thank you for being so patient in this afternoon full of works and workshops. So today I will bring you through a journey about photography and images used for the content. I saw many slices and presentations where I saw a lot of content and images being used, and I would like to explain you some things that we are going to see together. So from Mona Lisa at the Louvre, from a singer in a photograph, from the Tour Eiffel with illumination at night, and somebody who's taken a picture in a museum. Why are we looking at this? Because we have to consider some hypotheticals. When creating content for VR reality, you may decide to use an image you have already, a photograph you have taken, you have downloaded an image from the website, you have paid for that or you haven't paid for that, you were granted a license to use an image, and in this case you should ask yourself whether the image also implies the use on a virtual world or only for the other purposes, or you took a photo of an artwork which was located in a public space. What can you do with these images? What kind of use you can have in a virtual world, and which are the legal points you should consider when using them? So some of the things we should consider. There are photos and photographic works. I make the distinctions because in EU there are some countries where we have three kinds of photos, which are artworks, simple photos, or documental photos. And I will explain you later why this is important. It's important because of the copyright protection to which they benefit. So it could be 70 years, 25, 20 years. It depends from the EU country. Copyright is only one right. There are more rights. So, for example, the moral rights, the right to paternity and authorship, and the right of distribution, and there are economic rights. So we should consider which kind of right you need to have the image inserted in your content, and which are the negotiation you should lead with the owner or holder of the interest on the image. There might be an owner's right, author's right, or custodian rights. It depends on the kind of entity or artist or owner of the artwork you would like to have in your shooting and in your content. And you should check whether the photograph is still under the copyright protection and whether the artist is still alive. So let's start from the distinction I told you that exists in some EU member states from simple photos, artwork, and artistic or documental photos. We see two photos. These are simple photos. Yes, because there is no creative efforts. They are just representing reality as it is. So I would say that the work of the artist was limited. Let's go immediately to another kind of difference. Here we have the three kinds of photos: an artwork, documental, and simple. So starting from the artwork, we can see the photo of a famous Italian singer, and we can understand, it's on your right side, we can understand from the photo that he's performing. From the kind of personality we can deduce from the photo itself. So it's not explained, we don't see the stage, we don't see the public, but we can understand that he's performing because of the kind of light that was chosen, because of the black and white of the image, because of the face itself. So this artwork, this photo is called a photographic artwork, and it has the longest copyright protection, at least in some countries, for example, Italy and Spain. Then there is the kind of simple photos, and we have another singer, and you could ask yourself why there is the difference with the other singer, Zucchero and Venditti. Because this one on your left side, Venditti, you can see that he's performing because he is on a stage, there is the public, he's dancing, he's singing, so you see all the contents. You cannot adapt that he is performing just because of his face. This means that the photographer, in that case, in the case of Zucchero, put much more creativity efforts in the photo, while in the other it was a simple reproduction of a reality. The last kind is the document, and this is granted a 20 or 25 years protection from the date of production, while for the other is after the death of the artist. Documental photos is simply a reproduction of a document. So there is no creative efforts at all. It's just a simple photo of something that already exists. And in the three, we have the moral rights and the economical rights, but the protection, we said, is different. And why is this important for the content of VR? Because when using some of the photos, we can download from the website, we have to understand whether they are artworks, photographic works, simple photos, or documental, because in one case there could be still the copyright protection, and in the other could be shorter or no protection at all. So this is the first point we have to consider. Who is the right holder? The right holder could be, for the images, the state, if we are talking about images of artworks that are considered goods of the cultural heritage, so of the patrimony of the state. It could be the author himself of his estate and his heirs. It could, if there are commissioned works, there could be a conflict between the author who has the moral right and the commissioning party, who is the one who is vested with the interest in the work. Could be the press agencies or the archives for all the amount of photos that they have for decades, or the purchaser collector. But in this last case, please remember that whenever you purchase an image, from the website or materially from a direct dealer or a gallery, you are just buying the medium, you are not buying the rights. So if you have to use the image rights, you should be granted the image by a separate agreement, not just by the purchase, or at least remember to insert a clause whereby the rights are transferred to you. So the circle of the image, we can have an image, the author, who is the right holder of his moral rights and the use rights, the author of the artwork, which is inside the photo, and so the right holder of the artwork that is inside the photo, and then we need to understand which kind of usage we want to do it for the virtual world. So let's start from the photos of art which is in the photo. We have to define first who is the right owner or custodian. It could be a museum, it could be a state, we said, it could be the author himself, his estate. What kind of right do you need to put it inside the content of, for example, a virtual tour or virtual reality? What kind of conflict you need to avoid? For example, the photo on the right side of the slide, it was published by the Journal de la Photographie, but it was taken by the collector William Hunt, famous collector in New York. The photo that you see inside the photo is a photo taken by Massimiliano Gatti of Italy, and the photo was taken during a photo fair. So you can see that there are conflicts of rights. And of course, there is my image right because I was in the photo. And it was published without my consent. So whenever you need to use a photo, this photo was online and you could download it, you have to check the line of the rights and who owns the right that you would need to use it for the virtual tour. So check of rights, who is the right holder and what kind of right do you need. Let's move to a sort of justification that you could have, saying I can use this photo because there is a transformative use. This is a case that in New York that was settled 1 hour before the hearing, and I think it was a lost opportunity to discuss about the transformative use of photos. When the photo of the ground zero, raising the flag at the ground zero, taken by Thomas Franklin, was put together with the photo of Joe Rosenthal of the Second World War to do a sort of collage for a program of Fox News Channel. The funny thing is that the program was called Justice with Judge Janine. But despite the name and the fact that there was a judge, and it was called Justice, the assistant of Judge Janine decided that these two photos that were on the web could easily be put together and used without asking for the authorization of the right holder. So they justified the use, saying that it could be done because the use was transformative, because from two original photos, they did a collage of the two photos. So it was under the exception of the transformative use concept. The first circuit judge decided it was not transformative at all, because it was simply putting together two photos, but the elements of the photos were not changed. As I said before, they were sent to court, but the two companies decided to have a settlement and confidential agreement 1 hour before the hearing. So we don't know how much they paid for the use without authorization, but again, it's a pity it was not discussed on court, because it would have been interesting to understand the justification for the transformative use, which you can see it's not at all transformative, it's just simply doing a collage of two photos. Let's move to another justification you could have. You could say that you're using an image because it's a parody of an existing image. So on the right side, we see the floating piers. That was that installation done by Cristo on the lake of Iseo last year in Italy, which gathered millions of people walking on this yellow textile on the lake. Maybe someone of you was walking down there? No. Well, it's a missed opportunity. It was really a great experience. It was a floating pier from the coast to the center of the lake, and Cristo, the artist, was the one who invented this installation. Here on the left side, we have a famous painting that is at the Accademia of Brera in Milano. It's called The Fourth State, and we see the workers claiming food and a better improvement of their condition of life. But in any case, they are complaining. If we put the two things together, we can say we have a parody, because it's the floating piers of Cristo together with the Pelizza da Bolpedo painting and the people that are complaining. And we could say that they are complaining because the floating pier walk was really long. It was like sort of kilometers of walking. So this is a parody. Can we say that we can use photos because they are a parody of something else, and being put in a virtual world is a sort of transformation? No, we cannot say, because the last case of Kunz, which was decided last March, said that if we copy, or if we take as inspiration this kind of work, which is a photo, and we make a statue, this is not a parody. There is nothing humoristic, and there is nothing evoking a pre-existing artwork, because nobody knew about this photo because it has never been published. The same happened in Belgium some years ago, when from a photo we went to a painting, and the judge declared it was not a parody. There was nothing humoristic. It was simply a copy of something that was already existing. So the justification of parody in these cases could not be used. You should to evoke something precedent, but have also a mockery or humoristic sense. Let's move to something else. Can you put photos of food? Not if the food is German, because there was a case in Germany where the judge decided that the food porn, which is the habit of uploading the photos you took in famous restaurants to your social platforms pages, is a violation of the copyright of the chef. So you can, this is a sort of food porno, was created in '84 by an UK artist, and she said that food porn is a sort of pornographic art of food. So the judge said that if they are elaborated dishes and meals, the photos cannot be placed online because they are violating the copyright of the famous chef. if they are normal food, and that's why I put the photos of the würstel, they are not elaborated by the chef, so they could be used, also because it's not for a commercial use. Let's go to the freedom of panorama. I saw many images here in the presentation and in the workshop or in the videos downstairs, having photos of buildings and public art, displaying public spaces. The Infosoft Directive of 2001 admitted that EU member states could insert in their copyright rules a sort of exception to copyright protection. What does it mean? It does mean that the countries could limit the author's copyright and allowed people to use the photo also for commercial purposes. This is not the case for the lighting show of the Torre Eiffel because they are under copyright, because they were added later to the Torre Eiffel, so you cannot have a commercial use of them. And with commercial use, I also mean to the uploading on social platforms. And about the Infosoft Directive, I can say that some of the countries of EU are trying to harmonize with this directive and trying to grant exceptions of copyright. So France has already put a sort of clause. It's not clear whether it's referred only to natural person or also to entities. And Belgium is the last one who last July decided to give this kind of exception. So you can take photos of architectural and graphic and artistic artworks placed in public spaces only if they do not affect the normal exploitation of the work. What does it mean? It's not clear. There is no case law on the topic. If we move on, last topic about faces of celebrities, let's say only a few things because there is no more time. Can we justify the fact that we are using faces of celebrities for video games, virtual reality? It depends. It depends on the creativity and on the right of expression and the artistic freedom. In the case of the golf collage after the Master of Augusta with Tiger Woods, yes, it was not a violation of his image because it was the freedom of artistic expression which prevailed. In the case of Hart, it didn't. It was a violation of his image because his uniform was the same. He used at school playing for as a quarterback, and his face was the same, so there were no additional elements that make a derivative artwork. In the case of Rihanna, where her face was put on the t-shirt, there was a false, unauthorized endorsement, and his fans would have been led to believe that she has authorized the creation of the t-shirt, which was not the case. So, which are the legal tips? Use a white t-shirt as a content. Don't take photos of celebrities eating or eating in restaurant of refined chef-style dishes. The Tour Eiffel images only during the day, and art which is in public domain. But, as I said, that you have to get in touch with the author. I would like to finish with the famous author of a selfie, which was one of the leading cases of the last year, who is my dear friend Naruto. Maybe you heard about this selfie. Naruto is a 6-year-old crested macaco. He was in Indonesia and took the camera of David Slater, a UK photographer. He took some selfies. The selfies went viral, and there was this discussion about who owns the copyright on the selfie. Naruto, the publishing company, or the photographer who was the owner of the camera. The photographer said that Naruto was using the camera as an assistant, but I may believe that Naruto never signed an agreement because he was in the position to sign it. Then we could say that Naruto, is he really the owner of the rights because he has capability? Well, Naruto went to court. He filed a petition. He was defended by PETA, which is an association for rights of animals, which was also mentioned yesterday in another presentation. And of course, Naruto didn't attend the hearing. He was not allowed to enter, but he was domiciled by the association, and they say that he was capable of deciding whether to take the photos or not. So he was supposed to have the rights. He was not granted copyright because there was a lack of standings, but he could be an interesting precedent because we have a case of 2 chimpanzees in New York who were defined entities, and we have the case of the elephant in Indonesia who took a photo with a GoPro and a selfie stick. So maybe in the future you will have to deal with these kind of authors, because for the time being they are not copyright owners, but maybe in the future there will be an improvement. And also for music. For example, the whales' music, for the time being, is not under copyright, just because the wording of the law is not allowing them. But no, the wording is not even prohibiting them from being authors. So maybe in the future there will be a sort of, I would say, increase of kind of authors, and you will have to deal also with them. Thank you.